A new precedent was set when a decision recognizing chronic pain as a condition worthy of catastrophic designation was reached in the case of Pastore versus Aviva Canada Inc. Typically, a designation of catastrophic impairment entitles a claimant to apply for up to $1 million in medical and rehabilitation treatment, up to $1 million in attendant care benefits, and housekeeping assistance for life. This case is an important one for compensating accident victims because changes to auto insurance regulations in September 2010 have further reduced the standard policy of insurance to $50,000 for medical and rehabilitative treatment, $36,000 for attendant care benefits, and no housekeeping assistance. In November 2002, Mrs. Pastore was struck by a car and suffered a fractured left ankle and had to undergo a number of ankle surgeries. While she was recovering, she overcompensated on her right side, resulting in chronic pain in both her right knee and ankle, which affected every aspect of her life. Miss Pastore was a hard-working Italian matriarch. She not only held a job, but also tended to her home and her disabled husband. Being a traditional Italian woman, she took great pride in her home and her central role in keeping the family together. Following the accident, she could not work, look after her home and family, or even take care of her own basic needs. Her lawyer, Joseph Campisi from Carranza LLP, knows firsthand what this meant for his client and her family. His Italian upbringing enabled him to understand the cultural implications her injury had on her family and life. A medical team, including physiatrists, psychologists, psychiatrists, and occupational therapists, concluded that Mrs. Pastore had a catastrophic impairment consisting of a marked impairment in her activities of daily living. In 2005, she applied to her insurer to have her injury designated as catastrophic so she would be eligible to receive the enhanced accident benefits she needed to care for herself and her family. She was referred to a designated assessment center, which found that she did indeed sustain a catastrophic injury. Her insurance company refused to accept this finding, and after mediation failed, the issue was litigated at the Financial Service Commission of Ontario. The arbitrator reached the same conclusions as the designated assessment center, but Mrs. Pastore's insurer appealed. Ultimately, the Ontario Court of Appeal upheld the decision of the arbitrator, and with a catastrophic designation, Mrs. Pastore can now apply for the enhanced benefits that she needs. Mrs. Pastore has struggled for the last decade, unable to walk up and down the stairs in her home, and she has been in desperate need of enhanced medical, housekeeping, and attendant care benefits, and will now finally receive the benefits that she deserves. When looking for a personal injury lawyer to represent you or your family, it is important to find one that understands not only the ever-changing legal system, but also your unique situation and individual needs. As Toronto's largest ethnic personal injury law firm, we speak over 24 different languages and are ready to help.